Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started.
Thanks everyone for joining today. My name is Monica Cody, and I'm the senior paralegal at Jones Law Firm. I've been working in family law for 10 years, and I've been with Jones Law Firm for 2.5 years. Jones Law Firm has been serving the Denver metro area for over 20 years, and we do family law exclusively. We are Colorado's premier family law firm. Today, we have 3 of our senior attorneys here, and they will introduce themselves. Then we will talk about a very important topic, domestic violence and divorce. October is Domestic Violence Awareness Month, so we are here to get your questions answered and help you understand how to best protect yourself from a legal standpoint. First, I do want to make sure you know that your anonymity is protected. We will not disclose who is in attendance or who is asking questions. We only have a half an hour and a lot to cover, so let's get started with the introductions. David Collins, why don't you go first?
Yeah, good afternoon, everybody. My name is David Collins. I'm senior attorney with the Jones Law Firm. I've been an attorney for 17 years. I practice exclusively family law, which includes divorce, allocation of parental responsibilities, child support, maintenance, adoption, and all manner of parenting time-related issues.
Great, thanks, David. Erin, how about you go next?
Hi, yes, thank you, Monica. My name is Erin Mullen. I am also a senior attorney with the April Jones Law Firm, and I have been practicing law for, this will be my 21st year, actually in about 5 days, it will be 21 years. I have been with April, I've recently come on board with April's firm, and I'm really excited to be here. I have been practicing family law in Colorado, and I am practicing at about the area that David is practicing. Probably, I don't have as much experience in a few of those areas, but generally speaking, allocation of parental responsibilities, relocations, dissolutions of marriage, and with some ancillary issues associated with that. And I formerly, in a previous life, practiced criminal law and administrative law. And so, although I would defer to Morgan for any criminal questions, I do have the ability to spot issues fairly quickly. And so we can get teamed up with someone if there are ancillary criminal issues so that they can be addressed quickly. Thanks.
Thanks, Erin. And Morgan?
Good afternoon, everyone. Welcome. My name is Morgan Terrell. I am another one of the senior associate attorneys with Jones. I have been an attorney for almost 7 years now and been with Jones for about the last year. So as Erin kind of hinted, I do a combination of family law and criminal law. Those things tend to overlap sometimes. So I have practiced, I practice in both of those areas. And welcome, everyone.
Thanks, Morgan. Okay, so the first question submitted, I'm going to send over to David. Here's the question. I recently was arrested for a domestic violence incident that happened before the weekend. My wife and I are now getting divorced. How will this impact custody?
So that's a great question. I can tell you that domestic violence is probably involved in at least 25% of all the cases that I handle. And it has severe impacts for both parties. So the first impact it's going to have if you've been arrested for domestic violence is that there is very likely a mandatory criminal protection order entered immediately after you were charged and arraigned by the court, preventing the person who was charged from going anywhere near the other party, and that includes the marital home. So if you've been charged with domestic violence, there's a strong likelihood you cannot go home. The other issues concern who is in that protective order. The party who is alleging abuse will certainly be protected, but often the children can be in that order too. And you may need to ask the court to amend that to let the family law court address whether you should or shouldn't be restrained from your children. The other issue related to the immediate release is the conditions of your release. If you are arrested and released, you may have to post a bond. You may be put on alcohol and drug monitoring while you're on release. So there are a lot of things you may have to comply with immediately. Then when you get into the divorce case, domestic violence and the accusations of domestic violence can have a serious impact on the case. In family, especially with regard to parenting time. So that's really what we'll focus on here. It won't really, domestic violence isn't necessarily going to impact the separation of your financial estate. But with regard to parenting time, there are some significant possible consequences. And in parenting time, the court is going to make two decisions, one regarding who the children live with and when, that's parenting time. And the other is decision making, who gets to make the major decisions for the children. In Colorado, there's a statute that says if you've been a victim of domestic violence, the court can award decision making to either parent so that the two parents don't have to negotiate about major decisions. And the intent of that is they don't want a victim of domestic violence to have to negotiate with their abuser on major decisions. It doesn't mean the abused party will get the decision making, that's up to the court, but it can mean that the parties may not share joint decision making for the children. And that can be really problematic or difficult for parties to accept. If there's been an allegation of domestic violence, I can tell you that even if you are not found guilty, if the party who was charged with it either has the charges dropped or the case is dismissed or they win at trial, the family law judge can still find that there was domestic violence, even if there's no conviction. And if they do find there was domestic violence, that can and will affect decision making. It can also affect how the court views the person who is accused of domestic violence. The court itself can make a party take domestic violence classes or anger management classes, or take a host of other actions related to resolving the issue of whether a parent can be prevented from engaging in acts of domestic violence in the future. Lastly, I'll say if the children were present, you may also be charged with child abuse, and the court may take great concern about a parent who engages in domestic violence in the presence of children. Engaging in domestic violence in the presence of children is extremely toxic to the child, very difficult to undo, and you'll probably find yourself and your children in therapy to deal with the negative impacts of being exposed to domestic violence.
Yes, thank you, David. And attorneys, feel free if you have anything to add on, you can jump in and add on as well. Our next question is for Erin. My husband is emotionally and physically abusive to me. There have been multiple incidents in the past. I would like to file for divorce, but I have no proof that there was abuse. I've never called the police. It is important to me to convince a judge that there was domestic violence.
Well, as David said earlier, the relevance of your domestic violence is going to be relevant. And I think it's going to be relevant either if it's emotional or physical abuse. Because it is helpful if you have called the police in the past to have a record of that. However, it is not determinative. It's very common for victims of domestic violence to avoid the police, and it is equally common for them to file a report and then withdraw the report. There are all within domestic violence situations, there are other concerns for the victim, and that's going to be that if they prosecute, what will the repercussions be? If you have children, how will you care for your children, and will the perpetrator then use any attempt you make to prosecute the matter against you or the children? So it's not uncommon to not have a police record. What is important to note is that the burden of proof in family court is different from the burden of proof in criminal court. So even, and David mentioned this earlier, even if you don't have a conviction, the court in family court can still consider it. And in order to establish domestic violence for the court, for purposes of decision making, then you just have to show the court by a preponderance of the evidence, which means more likely than not. It's more probable than not that this occurs. And one of the things that I advise my clients to do is to create a list. Now, if you are still living in the home with your abuser, that is challenging because there's always the concern that they are monitoring you. But if you are able to, I would keep a journal, even if you need to keep it at a close friend's house, a trusted friend's home, with dates and exactly your best recollection of what occurred. It is much easier to demonstrate to a court that something occurred if we can come in and have you say, I noted this 2 years ago on January 1st. You might note the incident that surrounds it. Say we had left a holiday party, we got in the car, and that's when the verbal abuse began. I would make note of any circumstance that caused that you believe was the root of the abuse, meaning that if your partner has, an alcohol issue or a drug issue, if they had used those intoxicating agents before the abuse began, it all helps to build up a picture for the court so that they have an image of what happened. And you can absolutely be successful in convincing a court that there was domestic violence without any having ever told another person. That is also a helpful thing to note, is that if you have confided in someone about the abuse, then you would want to note who you confided, and if you are able, note when. And that also helps your attorney, because then we can go contact that person, we can interview them, and we can find out whether or not they would be an effective witness for you if and when we have a hearing.
Yes, helpful information, Erin. Thank you. Morgan, our next question goes to you. I want full custody because my partner has been physically abusive. How can I go about proving abuse? He has never been violent towards the children, but he has been violent towards me and in front of the children.
And that's a great question, and one that we unfortunately have to answer quite a bit in family law scenarios. And much like Erin was saying, even though the abuse is not directly taking place to the children, a court can still take that into consideration when deciding things such as decision making, such as custody, and all of the other things that are going to go into a court deciding a parenting plan. And so again, if you have a situation where that is ongoing or going on, all of the research shows that that can have a dramatic impact on children, and is them witnessing any sort of domestic violence, whether that be physical or emotional. And so it's absolutely something that you can bring to the court's attention and that a court can take into consideration. Again, it really helps an attorney in a court to make a decision about parenting time and visitation schedules when those things are documented in any way. So if there are text messages, if there are photos, if there are incident reports from the police department, all of those things can be taken into account. And while a court may not necessarily hear from the children directly, there are ways that a court can still sort of interpret what those impacts could potentially be on the children. One way of doing that is through a child and family investigator, and that's a report that gets filed with the court, and that person will speak with the children if they're of course of an age where they can be verbal, to really speak with them about the situation in the home and how it has been impacting them, and then can write up a report for the court so that the court will still get the perspective of the children without having them brought into the court setting to have to testify. So there are lots of different ways that can still be taken into account, and absolutely something that a court will place a heavy amount of consideration on.
Yes, thank you. And kind of another part to that question is just, I'm not planning to leave right away. I know when I do that my partner will get very upset. How can I make the best plan, or make a plan to ensure that I do leave safely? Morgan, I'm not sure if you wanted to comment on that as well.
Absolutely. Yeah. One kind of feeds into the other. And this is very common in domestic violence scenarios, or where domestic violence is present in a relationship, is that it often does take the party who is the victim of the domestic violence a long time to leave, or multiple times to leave. And as we know, that's just kind of part of the cycle, unfortunately. And so if you are in a situation where you're thinking about leaving, there are a lot of things that you can do to protect yourself yourself and protect your children. And, you know, of course, it's definitely fact specific. So that's a really good way that you can use our free consultations. We do offer free consultations because these can be so fact dependent. So, you know, if you give us a call, we're happy to set up a consultation so that we can talk to you about your specific scenario and your specific case. But things that you can do to protect yourself is make sure that you have a safe place to go, and a place that's going to be stable for you and your children. And whether that is a friend's place, a family member's place, a hotel, whatever that looks like for you and your specific scenario, make sure that it's a safe and secure place. Make sure that you have access to the financial institutions that you share with your spouse, if that is the case. Make sure that you're able to access your cards. Make sure that you're able to access those accounts online. That's very common in domestic violence scenarios for that not to be the case, where one party is sort of financially controlling of the other one. So do anything that you can to ensure that you will still have access to funds. And ultimately, I would say the biggest thing that you can do is just to have an organized plan, right? Make sure that you have your important property that you are going to need to take if you are leaving the marital home, whether that's your important documents, whether that's financial documents, things as simple as your social security card, birth certificate, anything like that, anything that is important for you to have, because these cases can take a really long time. And if it's a situation where you don't want to return to the home or you're afraid of retribution from your abusive spouse, you want to make sure that you're going to have access to the things that you need to have access to in the long term.
Yes, thanks, Morgan. And as Morgan stated, we do offer free consultations. You can give us a call at 303-799-8155, or you can visit our website at denverdivorceattorneys.com. To get in contact with us. Also, if anybody has any questions for our attorneys today, feel free to use that chat box and send your questions there, and we'll try to get all of those answered as well today. Our next question, go ahead. Yeah, Erin.
To just quickly add something to that, everything Morgan said was so important, because those finances, this is how a lot of people are manipulated. And when they're abused, this is a frequent, common way of doing it. Another thing that parties do when they're abusive is they will make threats. They will make threats to you or to your children. Of course, if in this scenario, we'll discuss protection orders. But aside from protection orders, if your partner tells you that if you leave, he will or she will take the children and you will never see them again, anything like that, there are also things that you can file with the court. You can file abduction prevention measures, a motion to request abduction prevention measures with the court. If you have a substantial reason to think that that is a possibility, then there are things that your attorney can do for you to help prevent that. It depends on the jurisdiction, how the courts treat it. Some court, I have actually heard one judge say, well, they haven't abducted the kids before, so this isn't an appropriate motion. That is not the case in every court. And even if it is not the case, once you've dragged that other person into court to deal with that issue, they are going to be more cautious, because they will then know they are under the scrutiny of the court, and what they do is going to be watched.
Yes, thank you, Erin, for that follow-up. Absolutely. Okay, so our next question, David, I'm going to shoot over to you. You had talked about protective orders a little bit. So our question is, there is a protection order between my ex and I, and we have joint decision-making in our parenting order from a couple years back. He continues to be extremely abusive towards me verbally and over text when I try to bring up things about the kids. Can I change the plan so that I have sole decision-making with our children? And do you think it's even worth reopening the case for?
So that's a great question. Let me start by saying we often have clients who come to us who already have a protection order in place, or we help them get one. Often that protection order will say they can't go within 100 yards of you, and that you two can communicate solely regarding the children, and often they limit it to either text messages or a court-required application like talkingparents.com. Monica and I have a case with very similar facts to this right now, where there's a protection order and the other party's being very offensive. And if you look at what is often paragraph number 1 of a civil protection order, it's that the parties cannot harass, molest, or disturb the peace of the other party. So even though in this hypothetical, the parties can communicate about the children via text or talking parents, the other party cannot harass, disturb, or molest the peace of the other parent. If the person is communicating in a way that is abusive, one, you can report it to the police as a violation of the protection order. That is an act of domestic violence all by itself and worthy of being charged as a crime under a violation of a civil protection order. It is also probably a sufficient basis to go back to court and ask the court to change joint decision-making, because you cannot engage in joint decision-making without being abused. And so you can probably do both. You can, I would screenshot capture the messages that you're being sent, because those are going to be exhibits where you can demonstrate the communication that's come through to you. And then two, a judge would certainly take a very close look at the behavior of the other party, and you have a strong argument to change decision-making to sole decision-making, especially if you've already been the victim of domestic violence, which is basically how you get a protection order in the first place, and then it's ongoing. So a court is not going to be happy if a party's been ordered to communicate civilly and can't. There's no need for mom, and sometimes it's dad who's protected. So I think, we've been talking as if mom is the protected party. We actually represent plenty of clients where mom is the perpetrator and dad is the victim. It's not uncommon for men to be the victim of domestic violence. Regardless of who the victim is and who the perpetrator is, the perpetrator can't keep abusing you, especially once there's a protection order in place. So we would advise that you probably can seek criminal charges and seek to modify decision-making.
Yeah, absolutely. Okay, so Morgan, I know you had talked about the Child Family Investigator, or CFI, so we have a question about that. We just got a CFI appointed in our case. How should I bring up the domestic violence that has happened in the past? My spouse is very charming, and I'm worried he will come off as a nice guy.
Yeah, that's a great question, and one that we hear a lot. I think I have several clients right now who are in that exact same position, and it can be a difficult conversation to have with your CFI, but also an important one. And so again, a CFI stands for Child and Family Investigator. This is a person that either the parties agree upon or the court appoints to do an investigation into what the living situation and the home situation looks like with both parties, and is going to make a recommendation to the court about what a potential parenting plan visitation schedule should look like ultimately. And so it is very important, I think, and I would always advise a client that they do need to bring up domestic violence to a CFI. That's absolutely an important conversation to have. I do think that the more that you can point the CFI to how it's impacting your children, the better. That's really what they're there for. And the focus of the CFI is going to be making a recommendation to the court regarding the children. And so the more that you can really focus on just how much that domestic violence has or can impact the children, and how what your concerns surrounding that are, the better you're going to be, and the more that the CFI can incorporate that into their report. And then essentially you're giving the court the information both about the domestic violence that's ongoing and how that domestic violence is going to impact your children. And the court can really take that into consideration when putting together a potential parenting plan.
Yes, good information there as well. Thank you, Morgan. Erin, I know you had talked about how domestic violence can kind of, and how it deals with the financial side of things in a divorce. Our next question is about property. So what happens if I leave the marital home to stay with a friend? Does that mean I'm going to give up the claim to the house or my belongings in the divorce?
That is a great question, and it's a real concern, especially for someone who has talked to family or friends who've been through a divorce in another state. States vary on this, but Colorado is a no-fault state. You will not be penalized for leaving the home. And in fact, where there's domestic violence, evidence of domestic violence, then you are not going to be penalized if you have to leave your children with the perpetrator, if you have to get out to find a safe place. So you can leave, you can go stay with a friend. There will be no penalty for your property division. And in fact, there's not going to be a penalty. I think David said this earlier. If you have one party who's an abuser, they're not going to be financially penalized for that in the context of division of assets. It can come into play in the sense that sometimes abuse takes the form of one partner suppressing the other partner's ability to work. They might prohibit that other person from working. They might have limited their access to funds. It would come into play, but not through the domestic violence. That would come into play as a typical property allocation in Colorado, because your property, if you under certain circumstances that when you're entitled to maintenance, that can assist you if you have been a party who has not been permitted to work and who has had to rely on the income of your partner, depending on the term of your length of your marriage and the other assets. But no, it's not going to have any bearing, and it's not going to have any bearing on you, and it's not going to have any bearing on them either, frankly.
And if I can just add to that,
Yes.
usually this happens when I do a legal aid night. I meet with, different people in 15-minute increments, but I've had so many women say, I just wish I could leave the home. And I always say, you can. There's no law that says you have to stay there. And it really, as Aaron said, it doesn't affect your property rights. It doesn't affect your parenting rights. You have absolutely no obligation to keep living with someone you do not want to live with. And it doesn't give them any leverage, except for that they're in the home, obviously, but it doesn't give them more right or authority over any property or the children, for that matter.
Yes, absolutely. Thank you, David and Aaron. Very helpful and good information to share. David, I know you had talked about that domestic violence doesn't just affect women, but men also. So our next question is, my wife is the one who started the fight, but when the cops came, they arrested me. How can I prove that I'm not the one being abusive?
I looked at that question. I thought, I want to hand this off to Morgan, the criminal defense attorney. I was actually a domestic violence prosecutor to start my career. I spent two years in court every day just prosecuting domestic violence. And really, this question goes to evidence. You need to gather evidence of the domestic violence. One thing I did learn as a domestic violence prosecutor is the day that somebody gets charged is not the first time that domestic violence has happened. It's often the 20th, 50th, or 100th time. It takes victims of domestic violence a long time to report. So if you were the victim of domestic violence, you likely were the victim over and over again prior to that. And maybe you told people. If you did, as Aaron said earlier, you sort of have, and you've seen this in TV shows and the movies, where you have a history of telling people what happened when it happened, and they can come to court and validate the story you're telling. And that's really impactful to whether you can produce evidence that you're really not the perpetrator, that you are the victim. And it's not uncommon for police to show up at a crime scene and they don't know who to charge. And so maybe they charged the wrong person. And maybe it's because of gender, but maybe it's just because they don't really know who to believe. And one person has substantial injuries and the other doesn't. So, but at the end of the day, you're going to need evidence to convince either the court in a criminal case or the judge in a family law case that you were actually the victim and not the perpetrator.
Yes. Morgan, did you have anything to add?
I absolutely agree with everything that David just said. And unfortunately, especially if you're a male and you're the victim of domestic violence, we're starting to get more and more research about that and what that looks like, because historically, that just hasn't been the case. Historically, a lot of people have just seen women as the victim of domestic violence and men as the perpetrators. Now we're starting to learn that just isn't the case, and it can very much go both ways. And so sometimes, the police officers, and it very much depends on what jurisdiction you're in. Sometimes the police officers haven't received that particular training, haven't been exposed to that. And so a lot of it can be just based on gender. The other the other reason that can happen sometimes is because the way that the Colorado statutes are written is if the police officers show up to a scene in which domestic violence has been a complaint from one, either or both of the parties, and they have some evidence to support that an act of domestic violence went on, they have to make an arrest. And so they're making that arrest without a ton of information. Really, it's just the information that they can glean from the parties, but the law says that they have to make an arrest. And sometimes they get that wrong. And that happens pretty frequently. But that's the way that our law is written. And sometimes that can backfire and the wrong party gets arrested. So the more that you have documented about the relationship as a whole that, perhaps the officers didn't listen to, or the information that the officers didn't get when they were on scene, like David said, the better.
Yes, thank you both. Well, we are out of time. I do hope that this was helpful. Thank you, Erin, David, and Morgan, for spending time today to help people with this really important topic. We will be sending out a document with resources to help you or anyone you know that might be in a domestic violence situation. Please feel free to share it with the people you know, so that they know that there is help out there for them.
Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at denverdivorceattorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.